I'd like to introduce our presenter, Scott Giordano. He's the VP of Data Protection at Spirion. Scott is a highly regarded data privacy attorney with over 20 years of experience. So Scott, take it away.
Wonderful. Thank you, Shane. Thanks everyone for joining us. And yes, please do answer the questionnaire at the end. This is how we get ideas for all of the upcoming webinars. So let's go to the first slide. And by the way, I do also want to encourage people to send in questions as I give the presentation. Also, if you sent a question in previously, I have a special place for that towards the end, and I'll make sure we all get those done as well. So with that, if you leave with nothing else, as of right now, CCPA is the most comprehensive U.S. state data protection law we have, and it's likely going to be our national standard. It is not a breach notification law. I can't tell you how many times people have said, oh, we're good, Scott, we're breach ready, etc. That's wonderful. It's not going to help you terribly much with the bulk of CCPA, as you'll see as we go through this. It does borrow many of the elements of GDPR, and I will point those out as we go through. In some ways, it's more demanding. Also, understanding where personal information lies in your business and how it's being used, how it's being shared, and how it's being protected is key. Finally, this statute is not going away. I know this is one of the things I keep hearing when I go to conferences. The legislature is going to defang it, all of this, or it has defanged it. No, it hasn't. The changes that were made by the legislature weren't terribly big. They were, in fact, just tinkering around the edges. And by the way, don't put anything in your online privacy policy that you can't defend. This is something that I'll talk about during the course of the presentation, but I wanted it up here as well. This is a big gotcha, as I'll describe. Also, don't wait to begin preparing for this. If you haven't started, now is a very good time. Even though the regs don't go live in the sense that they're going to be enforced by the AG until the 1st of July, the challenge is that the Section 150 requirements for information security go live right away. And a lot of those are connected to the regulations, as you'll see as we go through this. So they're all fairly well tied together, so don't wait. It's a fairly lengthy process. So with that, let's go to the first substantive slide. So the regulation contents. There's 24 pages of material in the regulations, which doesn't sound like a lot, but there's a tremendous amount. 3 areas in particular I'm going to touch on. So notices of business practices for getting consumer requests, and then verifying the requests, which is probably the toughest one of all 3. So let's go to the next slide. And also want to mention what's not in the regs. A couple things that you would hope would be in the regs that are not. So information on de-identifying or aggregating personal information, not in the regs. So if you were looking there for that, it's not there, at least not there yet. How to cure a breach. Note that the CCPA law itself, the statute, has a section on the ability to cure a breach. And if you cure a breach, then in principle, some legal actions are barred. But the problem is that they haven't given any information how to cure the breach. So that's to be determined. There's no citation to any kind of reasonable security framework, whether it's the CSC Top 20 or ISO 27K or anything else, even though it's an important component. And in fact, I've cited in red information security sections here. So those of you from the InfoSec world, please do pay attention to those in particular. Also, there's no details on these so-called third-party identity verification services. It's a brand new concept, nor is this idea of an authorized agent, no details on that. So I imagine that that's going to be determined, or things will just start popping up in the trade press, and perhaps that's where we'll get our information. I hope that's not the case, but unfortunately, this is where we are right now. So let's go to the next
Scott, I've
slide.
got a couple questions already.
Yeah.
They're coming in.
All right.
What do you think the timing is for becoming a national standard, and what other states have similar standards today?
Timing for national standard, I think what you're going to find is that as of January 1st, it's going to be a national standard. I know that Microsoft's already said that they're going to treat folks from all 50 states under this standard. Also keep in mind that we've got CCPA 2 coming up in the November election. Will be on the ballot. I'd be shocked if it didn't pass, which means that that's going to be essentially set in stone. And I don't think the federal government is going to mess with that. So the net of it is that it's effectively a national standard from January 1st.
Okie dokie. And what should we be doing right now for Nevada state or SB 2220? 220.
SB 220
Yes,
is
sorry.
really have a very, that's all right, I just have a very good idea of what information you're collecting and processing as an online service, and make sure that you're able to package that up correctly and to communicate with prospects, or I shouldn't say prospects, really just people that potentially are impacted by it. I can do an entire session on 220. In fact, I could do an entire one on all the new state data privacy, and I think I will. But the net of it is, for Nevada 220, SB 220, just make sure you understand where information is in your system, and are able to package it up and address all the requirements. Really, the discovery piece of it is probably the most important.
Okay, that was it.
All right, so general provisions. We already talked about that. Let's go to the next slide. So 3 sections on notices to consumers. So you've got this notice, which is really at the point of the collection, you have to give notice of what you're doing with the data. A notice of right to opt out, which is more or less tracks that more or less in parallel. And then your privacy policy, which, as you probably all know, is your privacy statement or privacy notice that goes on your website. So let's dive in to notice at the point of collection. I want to talk about that. And note that there's a lot of material here. I'm going to hit the ones that are underlined. And by the way, if you see it underlined, I underlined it. That's not in the original regulation. So first up, there's this plain language requirement, which says that you must use plain, straightforward language in your privacy. In your notice at the point of collection. You have to avoid technical and legal jargon. And obviously, I'm heartbroken at the prospect of not using legal jargon, but I think avoiding technical jargon, very good idea. I've seen a lot of really dumb stuff where organizations will put on their privacy statements or their collection statements that they use AES 256 encryption or something like that. It's just ridiculous. All it's going to do is come back to haunt you. Don't do it. Also, use a format that draws the consumer's attention and makes the notice readable, including on small screens. Now, why am I highlighting that? Small screens meaning your mobile devices, and which means that you need to speak with your UX, UI folks that work on mobile apps and other kinds of apps like that, where small screens are in scope. Also, on item E, where it says be visible or accessible, where consumers will see it before any personal information is collected. So the idea is that you want to make sure that they have to see the information before it's collected. Otherwise, it's not valid, and that collection is no longer valid. Let's go to the next slide. Okay, so again, notice at the point of collection, notice must be given at or before the time. We know that. Now, here's the thing. A business cannot use the information for the purpose other than that which it was disclosed at the point of collection. And if you want to change the purpose, you have to go back to the consumer and get affirmative consent. That sounds just like GDPR, you're probably thinking, and you're right. All 3 of these points are all copied and pasted from GDPR. So a great example of how GDPR is influencing this yet again. Let's go to the next slide. Okay, so more stuff you have to notice or put in the notice contents. One of the things you have to do is you have to have a list of the categories of personal information that's going to get collecting about the consumers. And each category, when you write about this, you have to provide a meaningful understanding of the information being collected. What does that mean, Scott? That means that you have to be able, in my view, in a single sentence, describe what you're doing with the information. And this is very much influenced by GDPR. And when we talk about a meaningful understanding, you can bet that's going to be litigated absolutely in court. There's no question about it, because someone's going to say, oh, I did provide a meaningful understanding. So the net of it is that make sure you can boil down what you're doing with the data to something that is useful to the end user, useful to the customer. I've seen so many of these statements that have been drawn up before that are so obtuse that you can't figure out what they're really doing with the data, and it's not going to work. Also, for each category, describe the business or commercial purpose for which it's going to be used. So when we say business purpose, we mean an internal purpose. You could say it's for auditing or security purposes or debugging or what have you. For commercial, it means making money. So you have to describe that. Again, this is also borrowed from GDPR, where you have to describe why you're doing what you're doing. So the purpose for which you're processing. Same idea, absolutely. Let's go to the next slide.
Scott, we've got a question.
Yes. Sure.
How does this fit into regulatory compliance programs?
It is one component of a larger regulatory compliance program. So think about when you have a data protection program and you have all kinds of things that you're trying to comply with. It could be, say, you're a hospital and you're complying with larger HIPAA high-tech, or it's a federal mandate like GLBA or what have you. The net is that this is just one set of requirements you have to rationalize. And when I say rationalize, meaning you line them up on a spreadsheet and you get an idea of what you have to do through all of the sets of requirements, and then go to the most stringent one and use that as a standard. So effectively, say you're doing international business. You look at GDPR, you're looking at operations requirements perhaps in China or in Brazil or wherever else you operate, line them all up and determine which one's the most stringent and adhere to those. That's effectively how you would do all of this. Otherwise, everything would be a one-off and you wouldn't be able to really get much done.
And then when or where do you suggest that companies start to become compliant? Will just a notice be sufficient to start?
No. If you're going to become compliant, you've got to wait until you've got it all ready to roll. Here's the problem. Say that you roll out a privacy statement, a privacy notice, and that's really good. You've done a great job drafting it, except that your internal practices don't match that. If the FTC sees that and you get into trouble, you get hacked or you lose data or you have another Cambridge Analytica, you're going to get destroyed because they're going to say, wait a minute, you made the statement and you're not following it. So that's why in terms of starting, you can start with whatever you want, but you really don't want to go live with this until everything's ready to roll. If you just do it in pieces, that's going to be tough. What I would do is focus on the 20% of the effort that's going to give you 80% of the value. So that's going to be your privacy statement, your collection statement, anything that's customer facing that people are going to see. I think you should start with that, but then you have to ask yourself, is that reflecting reality? Especially for things like verification. That's going to be a long process we're all going to have to work out on our own because there's no standards for verification. So the net of it is that there's not one perfect place to start. Start with anything that's going to be customer facing because you'll have a lot of stakeholders. You'll have, for example, legal and perhaps marketing, perhaps product development. If you have a web presence, all the people that design your web, all those people are going to be stakeholders. I know it's a long-winded answer, but there's no shortcut to this, unfortunately.
All right, that was it.
Okay. So notices to consumers. The question I get with some regularity is, suppose you don't collect personal information directly from consumers. You might believe that the party that did do the collecting is the one responsible. Not necessarily. And this is a gotcha here, folks. So say that you don't directly get the information, okay? You don't need to provide notice. But before you can sell it, say for whatever reason you want to sell it, and again, sell it, there's a very low bar to what constitutes a sale. You've got to then go contact the customer directly and get their permission. Problem is, and give them an opportunity to opt out. Problem is that if you didn't contact them directly and get it from them directly, it's going to be tough to contact them. So you could go to the source and ask them if they've complied with sections A and B, which is basically just basic privacy protections, and get signed attestations from them saying, yep, they're on the ball. Here's the problem, folks. Good luck getting signed attestations from these folks because they don't know where they got the data from. That's the problem. And so you're really in a tough place when you got information from a third party, unless that third party has already come out and said, yep, here's our blanket attestation. We know what we're doing. You're not going to be able to sell that information. So again, you can use it internally, but as far as transferring it to others for some kind of payment or some kind of value, can't do it. So again, this is a huge gotcha. Be very, very careful before you sell any kind of California resident personal data based upon this. Let's go to the next slide. So more plain English. I'm not going to belabor the whole plain English thing about it. What I do want to emphasize here is that you have to have a link that says don't sell my personal information or don't sell my info or what have you, or you have to have it either on the download or on the landing page of a mobile app. Again, I'm highlighting mobile apps because if you are like most businesses, you probably have a mobile app you use to communicate with your customers, and perhaps you log into your account. I mean, it seems like everyone's got a mobile app. It's amazing, quite frankly. You're going to have to get your UX UI people here to go make the appropriate changes, because a lot of times these things they don't work until you really test them, and customers always find a way to break things. So again, make sure that when you get your do not sell my info link all set up, make sure it works on all of your mobile devices, whatever format that you're using. And also think about, is it going to work on Android versus iOS, et cetera, et cetera. Let's go to the next slide. Okay, so exemptions. Are there exemptions to this? Yes, the answer is yeah. I get this question all the time. If I don't sell personal information, am I subject to CCPA? The answer is yes. Even if you don't sell the information, you're still subject. But for purposes of right to opt out, if you state on your privacy policy, which is, again, you're publicly facing notice, then no, you don't have to provide a notice for opting out. And in fact, we'll talk about a privacy notice on the next slide. So you're good there. But in fact, let's go to the next slide. Let's talk about privacy notices, which they still keep calling privacy policies. Yes.
I got two questions. If a company does not sell info, does it still need to be posted?
If you don't sell information, if you're using it internally, you don't have to have a post for right to opt out because you're not selling it to others, but you're still going to have everything else I described earlier. So you're still going to have a description for what you're doing with the data and the categories, the big five sets of information that I described earlier.
That was it. Thanks.
Okay, wonderful. So let us go to the next slide, and we'll talk about the privacy policy. And here's the challenge with a privacy policy. Okay, is that there is so much to get right, especially based upon all the regulations here. There's just a lot of information. And I remember when I was drafting GDPR privacy statements, and they were very laborious. It's going to be the same thing here. There's just a ton of information here. So you have to have a comprehensive description of your online and offline practices. So it's not enough to say, well, what am I doing online with the data? It's also things you're doing offline with it as well. So this is made very clear. It's not just online, it's offline as well. There's also another citation too, using straight, plain forward language, all that fun stuff, or straightforward language or plain language, whatever you want to call it. You've got to use that. All jokes aside, it's just going to be a standard now for everything that we do here. No technical, no legal jargon, etc. Also, back to making things readable on smaller screens. And you may think, Scott, you're beating this to death, but the fact is that this is something that is a gotcha. If it doesn't work on your mobile devices or things that are designed for smaller screens, it's just an opportunity for the AG to come down on you, or the FTC if it's a part of the privacy policy that you got wrong. So make sure if it's on a small screen, it works just as fine as it would on a regular interface. Let us go to the next slide. So again, another site to landing page on a mobile app. What's interesting here is that if you don't operate a website, if you're one of those companies that doesn't, you still have to make the privacy statement, privacy policy conspicuously available to consumers. Maybe you're a dry cleaner, for example. So you're one of the few dry cleaners that doesn't have a website, but you use customer information perhaps for some kind of offline marketing problem or project, I should say. I know I get Christmas letters or holiday letters from my dry cleaner with a coupon and that kind of a thing. Great example of that. You're still going to have to make the privacy policy available to consumers, perhaps when they come into the store. So again, this is something that applies both to online and offline applications. Let's go to the next slide. So more things. Right to know about personal information collected, disclosed, sold. So you have to be able to provide instructions for submitting a verifiable consumer request. What is that? That's a request, and I'm paraphrasing the statute here. It's a request that's reasonably verifiable by the business. I know that's not terribly helpful, but the idea is that you're having to solicit information from the consumer for verifying they are who they say they are. And we have a whole separate section on here just talking about verified requests. What's important is you have to describe to the consumer the process you're going to use to verify the request. And this takes a lot of thought, because suppose that you say, okay, give me a copy of your driver's license and a copy of your utility bill or whatever it is to prove you are who you say you are. Then that's something that you need to spin up now and get ready now, because you're going to have to describe that. And then if you change it, then you're going to have to update things and make sure everyone knows how you're using it. If you're using a third party, which I'll describe in a couple slides, then you have to say we use a third party verification service, which you may wind up doing because you may be overburdened and you may not be able to get this set up before July 1st. So the net of it is that there's a lot of material that has to go into the privacy policy, and this is something you really want to get started now.
All right, quick question.
Yeah.
If a company does not sell the info, does it still need to be posted?
Oh, privacy statements, absolutely, they need to be posted. Now, in the statement, if you don't sell it, then you don't have to put information about it. I mean, you can say we don't sell your information, which is probably the best way to go, but you're still going to have a privacy policy. There's just no way around this, folks.
Can a consumer file suit if they think that the verification process is too burdensome? That's a good question.
They won't be able to file suit because private rights of action are limited just to security failures, but they can complain to the Attorney General's office, and if enough folks complain, then the AG is going to bring the hammer down, or at least they're going to investigate. But I can expect that they're going to use this as a hammer to hit businesses that are not following this faithfully. So yes, absolutely, now is a very good time to review all that, because it's just too easy to get it wrong, and it's too easy for the AG to come down when someone complains, because that's how they're going to prioritize how they do things, just by looking at complaints.
All right, we're good.
Okay, so collection of personal information. So there's 5-ish categories, depending on how you look at it, that you have to reveal. So categories of consumers' personal information that you've collected in the preceding 12 months. So it's a rolling 12 months, but don't get too wedded to that 12-month rule, because CCPA 2 is going to do away with the 12-month rule. So presumably that's going to come down next year. It'll be live a year from now-ish. So don't fall too in love with 12-month rolling, because it's going to likely go away. So, and again, we got this information. The notice shall be written in a manner that provides consumers a meaningful understanding. So we're back to this idea of a very simple sentence that you can use to describe why it's being collected. And also the business and commercial purposes, again, the same principles we talked about earlier. And the notice shall be written in a manner that provides consumer a meaningful understanding of the categories. And again, I'm hitting this hard because you can bet this is where the litigation is going to come from. Someone's going to say that there was no meaningful understanding on your statement or your privacy policy or your notice or whatever communication you got. And as a consequence, I want the Attorney General to come down on you. So you can bet that the Attorney General, again, is going to use this to prioritize how they're going to enforce this. So be very judicious in how this stuff gets written, which means you need to start writing this stuff now and getting it vetted and getting it looked at with outside counsel, because it's going to be a long process. And you don't want to have to constantly change things and get it re-okayed, because it's going to have to get re-okayed by a bunch of people inside your company.
I've got some questions.
Yeah.
Can we publish our revised privacy notice on the website at the end of January 2020 without getting in trouble?
You can update your privacy policy or notice, whatever you want to call it, as much as you want, as long as you're making it easy for people to find out what's new or what's been updated. So there's no time limit in the sense that you can't make changes after the 1st of July. You can make changes as you need them. So there's no problem there. The issue is making sure people understand the changes, and that the changes otherwise meet all the plain language, no technical babble, etc. kind of stuff that I've been talking about for the past 30 minutes. So that's what's most important. There's no limit to how many times you could change your privacy statement if you really wanted to.
Okay. This is a good question here. What are the implications of giving, not selling, de-identified data for research?
There is an exception for research, so you're okay there, presuming that you're following there's an entire subset of privacy that deals just with de-identification for research purposes. And I don't have a lot of time to go into it, but the net of it is that there's already a carve out for that in CCPA, so you're good. So I'm happy to report at least some good news this hour.
Okay, I've got one more question.
Sure.
What's the best way to describe the data collected via cookies without being too technical?
Well, a great way, and I'm not saying that you just out and out copy and paste from other people's websites, but you'll find that many websites already do a very good job of articulating what information is being is being described or collected via cookies. So, and by the way, cookies aren't special. They're not called out in CCPA. They're just another means for collecting information. So, for example, I know in some privacy statements I wrote. I broke them up to strictly necessary, and there's 2 other categories that escape me, but I would use that setup that others are using already to describe the different kinds of cookies, and I would leave it at that. I think that that's fairly well written and fairly well developed already, and frankly, I'm sure others do the same thing. So I would just use that tact, and I think that's at least a very good place to start, if not to finish.
Okay.
All right, so let's summarize this in our next slide. So again, note the plain English requirements, plain English everywhere, no legalese, no technobabble, etc. So at your collection points, at your opt-out notice, and your privacy statement, you must indicate the purpose for which you are collecting information, again, like GDPR. And if you wish to use it for something new, you have to go back and obtain consent again. So think ahead so you don't have to chase people down. You are exempt from the notice of the right to opt out if you don't collect, but note the requirements. And finally, that privacy policy requirements are extensive, and get them right or risk the wrath of the FTC or the AG. Okay, let's go to Article 3.
All right, and I have another question. Could you expand a
Sure.
little bit more on that July 1st date that you referenced?
July 1st is when and this is based upon the Attorney General's statement, because the onus is on them to create the regulations, which they're not happy about. So they have a 6-month time limit that regulations must go live no later than 6 months from the time that they are published as final. Now, they haven't been published as final, but the deadline, the absolute deadline, is July 1st to go live for the regulations. So the net of it is that everything has to be ready by July 1st. I know that sounds like a long time. I can tell you that it's not. I've worked on numerous GDPR projects, and they are time sinks. This is going to be a time sink. So yes, the AG can enforce things starting July 1st, and with the exception of Section 150, which is information security, that's live at the end of the month. So on January 1st, information security requirements are live. Don't have a breach, because bad things will happen to you. You will get lawsuits. So the net of it is that all the other regulations that have been published, they're July 1st, the deadline to be compliant with them.
Okay. All right, we're good. Yep.
All right, business practices for handling consumer requests. Again, I'm going to zip through this because I want to hit verification of requests, so forgive me if I talk a little fast here. Couple things I want you to know. If you're a business subject to CCPA, you need to have 2 or more designated methods for submitting requests to know. When I say request to know, meaning it's a basically data subject access request. So those of you that have been familiar with GDPR, you're familiar with DSARs, it's a DSAR, okay? And at a minimum, toll-free telephone number, and if you have a website, which basically everyone does, an interactive web form or something that works on a mobile application. You can see I've highlighted those because, again, you need someone that knows how to get your website or your mobile device software working properly for that. Also, business shall provide 2 or more designated methods for submitting requests to delete. So remember, you can have 2 things. One is a request to know, your data subject access request, and then one to delete data. And note, you don't have to just delete everything. It's not an all or nothing proposition. You can simply have certain things deleted. It's not necessarily everything. You can also have things corrected as well. That was somewhat implied, but now it's actually black letter law. So let's go to the next slide. So more information. You have to use a 2-step process. So essentially, someone submits the request and then confirms. So sometimes called a double opt-in in marketing terms. Now, if you don't interact directly with consumers, okay, maybe you are in ad tech, for example, and you don't touch consumers at all. You don't interact with them directly, or you're in a supply chain or what have you. What you can do is then you have to have one method by which a consumer can submit online through your website or what have you. So again, even if you're a B2B player, but you think that you're going to get some kind of requests, it's probably a good idea to stand up a web page so that people can submit those requests. Or perhaps you're a supply chain member, you don't think you're going to be getting consumer requests, still a good idea to put up something on your website so that people can make a request. You may be pushing that to your supply chain members to get help, but at least you're putting something there. I highly recommend it. just as a default. If a consumer submits a request in a manner that's not one of the designated methods of submission, okay, or it's deficient, then you've got a couple options. You can treat it as if it was okay anyway, or tell the consumer how to do it right. But either way, this means that you're going to have some kind of ticketing system to track all this stuff, because you can bet that the consumers that ask for things and they don't get it, they're going to complain to the AG. It's always the squeaky wheel that is going to be the one that complains. So keep that in mind.
So I've got a couple of questions regarding that.
Sure.
As a processor, can our agents refer the customer to a website to make the request, or must it be done while on the phone?
Good question. If you for whatever reason you don't want to do it over the phone and you want to push them to, it's a good question. The short answer is I don't know. If for some reason you don't want to do it over the phone, I would put something up that you can push customers to if need be, because for whatever reason you don't have the bandwidth or the people aren't trained properly or what have you. In the short term, I would do that, but in the longer term, I'd take a hard look at making sure you could do it over the phone as well, or having a third party do it, which is probably what most folks are going to do anyway. So I don't know off the top of my head. Yes.
So to piggyback a little bit after that,
yep.
Do they have to have a toll-free number? So I think you kind of answered that. Or
yep.
Can we have a form and an email address only?
I'm very dubious that you can have a form and an email address, because they push that toll-free number pretty hard. I'd be very dubious about just trying to rely on it with a form and an email or something of that nature.
And then change of topic here. Can you talk more about Section 150 that you mentioned?
I can't except to say that it deals with information security requirements, which are not extensive, and I have an entire webinar on that. So what I'll do is when I get all the questions, Shane, we can send a link to the webinar I did that was just on Section 150. That way I don't take up too much time here.
Okay.
Okay.
We're good. Yep. Next slide.
All right. Yes, please. So some details on responding. I get these questions all the time. How much time do I have to respond? Well, you have to confirm receipt of the request within 10 days, okay? And provide information how the business will process the request. So remember, I've been talking about this whole hour, how you really have to be very careful in what you're saying in all your communications, because the first time you get it wrong, you're going to get caught. Someone's going to complain. So within 10 days, confirm. Frankly, you probably should have an autoresponder that just confirms, automatically, and has some kind of boilerplate that says how you're going to do things. That way, it's consistent throughout your entire process. And you shall respond to requests to know and to delete within 45 days. Folks, don't take 45 days, because here's the problem. Yes, you can get a delay. You can get a 45-day delay if you want to. Okay, it's possible. But again, you're really just risking having people complain to the FTC or the AG or what have you, and it's just not worth it. So ask yourself, can we get this done in 10 business days, for example, or maybe 15 at the most? Don't wait the 45 days and avoid asking for extensions unless this is a one-off or something really messy. Don't make it a habit to wait to 45 days. You're just going to get killed. I guarantee bad things will happen. Let's go to the next slide. Couple details about requests to know and to delete. Again, I'm not going to hit the whole list. There's about a dozen, but I want to hit at least the first 6 that I really like. If you can't verify the identity of a person making the request, don't disclose it and tell them that you can't verify their identity. I know it's going to make people mad, but if you disclose it to the wrong person, you're going to make them mad as well. And they're going to complain as well. If you can't verify the identity of the person making the request, again, deny the request, inform them that you can't verify the identity. So very, very important. And then finally, on this page here, don't provide consumer with specific pieces of information if the disclosure creates a substantial, articulable, and unreasonable risk of the security of the personal information. Folks, again, I put this in red because this is for the information security folks on the call here. It's so important that you have a watertight system that's going to be able to process these requests to know and delete from end to end. And if there's some reason that the information you're providing creates a risk, which means you need to do a risk assessment based on the information you have, then you need to say, no, we're not going to share that information. This is going to create all kinds of headaches here. Now is the time to look at the information that you're sharing and say, okay, how risky is this? If it's very mundane information, maybe it's not a big deal. If it's social security number, healthcare, bank account numbers, you can bet anything that's radioactive, that's going to be something you really want to take a hard look at.
I've got a question here. If we receive
Sure.
a request to delete, how do we get around regulatory record retention requirements?
Well, if there is a conflicting requirement with federal law wins. So, for example, the 7-year requirement for broker-dealers, federal law is going to win. So that's easy. Also, keep in mind, too, that in many cases, for example, GLBA or HIPAA or HITECH, what have you, or FERPA, a lot of federal laws are going to address that separately. They may have some kind of document retention period. Also, remember that I didn't talk about it earlier, there's a document retention period within CCPA. It's, I believe, a 24-month document retention period that I didn't really talk much about. So the net of it is that if it's a conflict with the federal government wins, go with theirs. And you can put that in your email you send to people that are asking for deletion. You can say, sorry, SEC says I can't delete this for 6 more years or whatever it is.
All right, I've got another question. Can the toll,
Sure.
This kind of goes back to what we talked about before about the calling and opting out, et cetera. Can the toll-free number go to a voicemail box which is monitored?
Ooh, good question. I don't know. Yeah, the short answer is that I just don't know. I would have to go look it up. So stay tuned. When I do the next webinar on this, I'm sure I'll have all these questions answered. But the short answer is, yeah, it's difficult to say. It's very difficult to get out of this toll-free number issue. Again, why you may well be using a third party to just handle everything.
That's it.
Okay, let's go to the next slide, and a couple other points that are InfoSec related. So a business shall not at any time disclose a customer's social security number, driver's license, or other things. So the point is, these are all essentially radioactive. So it's reiterating what we said on item 3 in the previous slide. It's very important to do a risk assessment and determine how much at risk these things are. Maybe they're not, which is great, okay? If you're a health insurance provider or healthcare provider, you're probably already well versed with this, but the overall is make sure you're not sharing information without doing a pretty stringent risk assessment so that if it falls in the wrong hands, you're minimizing the damage. Also, business shall use reasonable security measures when transmitting personal information. So remember back in the days where if you wanted to get some kind of information from a third party, they would send you a link and you would log into the secure website, etc. It may be that, or maybe the consumer portal that you're using if you already have a relationship with the consumer. Net of it is that you've got to use reasonable security measures. All the InfoSec folks on the phone right now, this goes to you. You guys are going to be asked to opine on this and perhaps to execute this. Okay, let's go to the next slide. Okay, request to access or delete. If a consumer does not have a password protected account, then there's all kinds of issues with aggregate household information. Essentially, you have to get everyone in the household to okay this. So the net of it is that if maybe you've got a bunch of roommates and you want household information from a third party, maybe it's a cable provider or a power company, you're going to have everyone sign off on it. Let's go to the next slide. Okay, so more information on this. I'm going to zero in towards the bottom where it says you shall not provide a consumer with specific pieces of information, again, if it can create a substantial, articulable, and reasonable risk. So I'm reiterating things because the regulation reiterates them as well. So the net of it is that make sure you're looking at the potential risk to a consumer and that you're mitigating it appropriately. We've got plenty of industry standards and frameworks like ISO 27K and CSC Top 20 and what have you. So make sure that you're doing it in that context. Let's go to verification. Okay, so verification is going to be the toughest one here, folks. So you need to put together and document comply with a reasonable method for verifying someone is who they say they are. And the reason why this is so radioactive is because you can imagine that private investigators are going to try and get information about people. Spouses, they're perhaps going through divorce, are going to try and get dirt on one another. So there's all kinds of mischief that's going to take place here. So you really have to put together a reasonable method for verifying, and there's really no industry standards. I mean, everyone makes it up. When I was working on GDPR projects, everyone was making it up. A lot of people were getting copies of driver's licenses and social security cards, or they were getting driver's licenses and utility bills, whatever it was, but they were getting information about identifying someone they are who they say they are, and they really live in state X or what have you, or in this case, country X or what have you. The problem is then you have to collect lots more information, and you have to process that and make sure that that's safe, and then destroy it when you don't need it. So here, CCPA says match identifying information with stuff you already have. That's great. Avoid collecting radioactive information, as I call it. So things like a social security number, driver's license number, etc., unless it's necessary. So this means you have to think this through very thoroughly about how you're going to do this. If it's someone you have an account with, it's easier than someone that is off the street. But you may just be getting random requests off the street for information, and verifying them is going to be a bit of a challenge, especially if they have a common last name. Let's go to the next slide. So, generally speaking, avoid requesting additional information from the consumer, but that may be unavoidable. And we're back to InfoSec. Shall implement reasonable security measures to detect fraud. So here we go. We're back to InfoSec and why we can expect people to be trying to game the system and getting dirt on people, on others that they are not entitled to. This is, again, if you're on the InfoSec team, this is something that's going to fall to you. Note that a business is not obligated to provide or delete information. If information is de-identified. So someone asked earlier, do I have to re-identify information, or perhaps keep it if I don't need it? The answer is basically, if you've got information that's de-identified, you don't have to provide it or delete it. It's done. Okay, don't have to re-identify it. Nothing like that. You're good to go. Let's go to the next slide. Third-party identification service, I mentioned this earlier. It's a security process offered by an independent third party who will essentially take the responsibility to verify someone. I don't know of any organizations like this, but I imagine they're going to start popping up out of the woodwork now, because this is a need, and they want, presumably you as a company want someone to take on that liability. So that's potentially what's going to happen here. Again, I haven't seen these folks pop up yet, but I imagine they will if they haven't already. Let's talk about verification of password-protected accounts. This is easy, okay? It's one of the few things that's easy here on the next slide. So if you already have a password-protected account with a consumer, just use that account for things. Shane, if you want to go to the next slide.
Yeah, actually I have a question.
Oh, okay.
Can or should we include a checkbox that the consumer attests that he or she has the authority to request info or delete?
Absolutely.
At least to prevent perjury on a web form.
Absolutely.
Okay.
And yes, absolutely. And you're welcome to put those boxes and say you're signing this under the penalty of perjury. Absolutely.
All right, next slide.
So next slide. So again, if you've got a password protected account with the consumer, you're good, unless you suspect some kind of fraudulent activity. And I'm not going to go into all of that, how you can detect that. Again, that's an entire webinar just on detecting fraudulent activity. But if you detect that, don't comply with it. It's safer in some ways not to comply and to further verify someone than it is to give them information perhaps to someone that's dubious. So you're good for password protected accounts. The challenge is when there's non-account holders, which is the next slide. So if you don't have an account with these folks, then what you've got to do is you've got to verify the identity like we were talking about earlier, match at least 2 data points if it's just basic information. So if it's a category of, say they say, tell me all the categories of information you have about me, then you have to match 2 data points provided by the consumer with data points you already have. Okay. Now, if it's something very specific pieces of information, you need 3 data points. So you can bet that this is going to be a big challenge. Also, you need to get a signed declaration under penalty of perjury. Someone just asked that. So yes, absolutely, that is part of the regulation if it's for specific pieces of information, which is what you really care about. So the net of it is yes, make sure that you've got that checkbox under penalty of perjury. Okay, let's go to the next slide. If there's no reasonable method that you can verify someone, state so and say, sorry, we can't help you. That's what you can do. There's just no way to verify someone, there's no way to verify it. Also, if you do this for everyone, make sure that's in your privacy policy as well. Okay, let's go to the next slide. I'm going to summarize things. I know we've got a bunch of questions, so I'm going to do my best to get through them. So, verification request in sum. Okay, so as a business subject to CCPA, you must create a reasonable method for verifying that requesters are who they say they are, which means that you're going to have to think this thing through. It's going to take a while. You're probably going to have to test it out to see how it actually works. You're going to have to use some kind of ticketing system to make sure you're tracking everything, make sure nothing falls through the cracks. As a practical matter, avoid collecting any kind of sensitive information if you can. So if you can avoid collecting SSNs or even driver's license numbers, medically related things, do so. And also develop and use reasonable security measures to detect fraud in the identity verification process. And so this is something that perhaps you have done in other contexts and you can apply it here to identity verification. The net of it is that it's going to fall to you as an InfoSec professional to do this. This is going to take time. You're probably going to have to perhaps buy new technology to create new controls here. Okay, let's go to the next slide here. And so your questions answered. And so these are questions that you've sent in. I did not edit them except to fix just bugs that came in through the web form. So after speaking to a lawyer, he mentioned he felt a company could avoid having to respond if he couldn't validate the request. Yeah, that's true. I just mentioned that earlier, that if you can't validate it, you don't have to, well, you have to tell them that you couldn't validate it. You can't simply not speak to them. So yes, the net of it is that you don't have to share information if you think it's going to create a risk of sharing it with the wrong person. Any focus on credit bureaus at the state level, and what it's probably referring to here is New York passed laws when they updated the New York State laws on insurance companies. They also added credit reporting agencies. So I think the net of it is that that's applicable in New York now. I wouldn't be surprised if other states passed it as well. They're already doing it for insurance carriers. I wouldn't be surprised if they added that for the credit reporting agencies like Equifax and TransUnion, et cetera. Are you seeing these regulations being used as a template for other states? Yes, absolutely. Washington State's they tried to copy this last legislative session. Undoubtedly, they'll do it this session. Texas also tried it last session. You'll see a lot of states will come out, and I think this time the majority of them will actually pass. Is there any talk of federal regulations? Yes, there's talk every day about it, but I don't see it going anywhere. It's just one of those things that's great to talk about, but for reasons I mentioned earlier, I don't see any federal legislation coming into play at this point.
Scott, I've got a question here.
Yeah.
Does CCPA have any relevance for companies' employees within California, or is it only consumer oriented?
Well, and that's a wonderful question. Originally, the folks that started CCPA didn't contemplate employees. So originally it was just consumers, and then as the law that was passed was really analyzed by people in the industry, they believed that it was covering employees. Then at the last minute in the legislative session, employees were not covered, but only for 1 year. So they're exempt, but only for 1 year. But CCPA 2.0 exempts employees completely. So the net of it is that likely CCPA will not apply to employees in the near term, at least for a year, and perhaps not forever. Okay. Other questions that you've got before I go through these? Okay. So someone asked, can you discuss the similarities and differences? I presume they mean between CCPA and GDPR. We have some bonus slides on here that I won't show, but you'll get them when you do the download. And they've got all kinds of differences and similarities between CCPA and GDPR, so you're good there. What impact will Shine the Light have on CCPA? None at all. So Shine the Light is a fairly old law. It's probably 10 years old, I'm guessing. And the idea was that you had to, on request, share information with consumers about any third parties with whom your information was being shared for direct marketing purposes. So for sending you an email or perhaps a phone call or what have you. And you still can do that. It just doesn't really have any impact on CCPA. Next question is, are there any documented industry thresholds where the combination of secondary PII elements should be viewed as PII? No, and frankly, I would get out of the mentality of thinking about secondary PII, and here's why. Because, yeah, you could say that SSNs are more dangerous, and that's true, but the point is that you can take very little, quote-unquote, secondary PII and cross-reference it, and you can identify someone positively. And I did a discussion of this at IAPP one year, a couple years ago, and talked about this. And I was shocked at how easy it is to find out someone's identity just by looking at credit card transactions, for example. So net of it is, don't think of things as secondary PII. Even with secondary PII, you can do a lot of damage. Next question is applicability of CCPA to a large general contractor with business nationally. No different to a large general contractor than it is to anyone. If you've got consumers that you do business with, okay, then you are going to be subject to CCPA. There's just no way to get around that. So yeah, there's no difference. Don't treat it general contractor different than you would anyone else. Which data protection privacy regulations or laws have gone nationwide? You can argue the New York Shield Act, which is, I won't call it their CCPA because it's much more limited, but that's effectively going nationwide because so many people do business in New York. So that's another one, and I think when we do our state privacy roundup in the new year, we'll talk about that. I think we've got one more question on the question list. Shane, if I'm not mistaken. Yes. Is there a clear definition of the various categories of personal information we need to return? Yes, your Section 110 requirements, they've got the 5 different categories. And really, the most important one is specific pieces of information. I think if that's all you gave someone, they'd probably be happy. But as a practical matter, you have to tell them where you got the information. So the categories of sources, like a data broker, for example, the categories of information. So, name, address, etc. So you have to tell them all that, but really what they care about is what kind of information you have on them. So, so that's it.
I've got a question that's come in just to kind of verify something you said earlier.
Sure.
Did I hear you say that we need to have a toll-free number to field data access and delete requests?
Yes, you do.
Okay.
And I know there's a lot of unhappiness about the toll-free number. I know folks were trying to find a way to get around it, but just my reading of the regulations is it's going to be tough to get around it. I like the idea, though, of having a recorded number. I will go run that to ground, and I'll make sure that on our next webinar, which will be next month, we'll go into that and make sure that we address all of that.
As a processor calling or working on behalf of a client or business, do we take the requests as a request for the client, business information collected, or our business?
Oh, I understand the distinction. I don't know if it's a meaningful distinction, because here's the problem: is that you're going to probably, I hope, amend your contracts with your clients, where you're going to say, look, Mr. and Ms. Client, I know I'm going to get DSARs. I know people are going to come in and say, what do you have on me? I'm going to pass that to you, because I'm just a service provider. So I would accept the request as a business with a capital B, okay, even though you're a service provider, and make sure you've got a relationship with your customer, who's the real business, making sure that they're going to be able either to pick it up from you or give you the information that you need to fulfill it. So that's how I would do it. Don't obviously rely on the business to do it. Have a plan B, but I would really make sure that they understand that. Okay. Any more questions before I wrap things up?
Nope.
Okay. So this is going to involve more than IT and legal. As I've said multiple times, get your website and your mobile designers on this. Mobile apps were cited 5 times in this regulation. That's a lot for a 24-page regulation. Get your data inventory going. You've heard me talk umpteen times about data inventories, but they're still the basis for everything else. You've got to know where the information is. Then get your DSAR process going, or whatever we're going to call it. I don't know if we'll call it DSAR, but that verifying the requester part is going to take up a lot of time and effort to get it right, and it's easy to get wrong. Make sure that you spend the time and start on it now. Determine what you're going to put into the report that you give the end user, okay? It's very easy to give them way too much, and then they're just going to write back and say, what is all this stuff? So think about that when you're actually doing it. Determine how you're going to get it to them. I mean, if it's in their customer account, that's great. You may email them, you may snail mail them, but make sure that you've got a consistent process. I mentioned earlier about having a ticketing system or some other protocol to make sure nothing falls through the cracks, because those are the folks who are going to get angry, and they're going to be calling the AG's office. And prepare draft updates to your privacy statement now, and think about having a California-only section on your website. I know that some folks want to have an all-encompassing privacy statement. I'm not in love with it. It's just too easy to miss something, in my view. I'd rather have a jurisdiction-specific section. That's just my personal preference. There's a link here that you can copy down real fast. That'll also be on the slide deck. That's the research page that is for California AG. It's got everything on there. It's got the regulations. It's got all the notifications around the regulations. It's got just all kinds of stuff. So do have a look at that when you wrap up here today. I think you'll get a lot out of it. And then I think we have a screenshot here of a data inventory, which you've probably all seen before. There we go. So the items in the red box, that is the personal information that would be subject to GDPR and CCPA and so forth. This is a real piece of a real data inventory that I did a couple years ago. And finally, our final slide here, I believe, is that's it. We do have a CCPA compliance white paper as well, and look for new ones in the new year. As this law is updated, I will be updating the compliance documents as well. And unless we have any more questions, I will turn it back over to you, Shane.
All right, well, thanks everybody for joining us today. Remember, you'll get a copy of the PowerPoint presentation and a link to the recorded webinar within the next week or so. And we hope to see you with any of our future webinars. Be on the lookout on our webpage in January. And everybody have a great day and a safe holiday.